Today we're going to talk about transfer on death deeds and pay on death accounts. My name is Gregory Singleton. I'm an estate planning and probate attorney who lives in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and greater Minnesota alike. Just as a reminder, if you like today's video, please feel free to hit that like and subscribe button. It really helps support the channel. Also, a couple caveats before we get going. First of all, these videos are for educational purposes only. I am not giving legal advice or creating an attorney-client relationship with everyone on YouTube. Secondly, we're going to talk about Minnesota law here, very specifically Minnesota law here. So if you live in another jurisdiction, a lot of the concepts will probably apply to your jurisdiction, but just make sure to talk with an estate planning professional before you plan your estate. So, transfer on death deeds came about in Minnesota in 2008, which is not that long ago in the land of law. Pay on death accounts have been around since 1973. So what are these accounts and why do we use them? So a transfer on death deed is under Minnesota statute 507.071. What it effectively does, it puts an official beneficiary or attaches an official beneficiary to a title of a real property. Notice I said real property. Transfer on death deeds are just for real property. How flexible is this is really the question. Can you have multiple beneficiaries, such as Abraham, when he dies, wants to transfer the property to Benjamin and Susan? Yes, he can do that. Can multiple grantors do a transfer on death deed? So Benjamin and his wife Julie, when the second of them dies, they want to transfer the property to Benjamin. You can do that, absolutely. Can you have successor beneficiaries? So Abraham wants to give the property to Benjamin, but if Benjamin doesn't survive him, the property goes to Susie. Yes, you can. You can do all three of those things. Can you do a transfer on death deed and then change it with a will? So Abraham, when he dies, the property under the transfer on death deed is going to go to Benjamin. Then Abraham writes his will and says, I want my property to go to Susie. Who's going to get the property, Benjamin or Susie? Well, it's going to be Benjamin in this case, because a will cannot supplant what you do in a transfer on death deed. So let's talk about pay on death accounts. They're very similar. Here, you're making an official beneficiary to an investment account or a bank account. It's under Minnesota statute 524.6-201 for those that want to look it up. It is slightly different than a transfer on death deed. First of all, topically, it is not for real property. It's for bank accounts and it's for investment accounts. But secondly, let's say you have a pay on death account where Ben, Abraham again, upon Abraham's death, the property is going to transfer to Ben. But then Abraham says, you know what? In my will, I give that one bank account to Susie. Which is going to control? The pay on death account or the will? In this case, the will controls. So Susie would get all the assets in the bank account because we specifically identified the assets and specifically identified the bank account. So how does one do the transition from the grantor to the beneficiary when the grantor dies? In the transfer on death deed, you're going to send to the county recorder a death certificate and an affidavit of survivorship, which any attorney should be able to draft for you. The affidavit of survivorship is recorded, and all of a sudden, the beneficiary owns the property. No probate. What about the pay on death account? It's a little bit different. You're going to need a death certificate, which you will provide to the financial institution, and then you'll contact the financial institution and say, hey, the grantor died. I'm the beneficiary. What form do I have to fill out? And they will give you a form to fill out. You'll fill it out, and then bada boom, bada bing, the property should transfer right over, again, without probate. So the question I'm often asked, and they almost always ask this just in relation to transfer on death deeds, is what rights do I have if I'm the grantor and I'm giving a property to I'm appointing a beneficiary to a property, what rights do I have on the property? So let's say Abraham appoints Ben as his beneficiary, and then Abraham, before he dies, decides to sell the property to Jacqueline. Can Ben come in and say, no, you don't get to sell that property? Or can he come in and say, I want a cut of the proceeds? The answer is no. There is no right of revocation, or the grantor has full right of revocation. He can take Ben off the transfer on death deed. He can add somebody else to the transfer on death deed. He can sell the property, and all of a sudden Benjamin is no longer on the transfer on death deed. The person who is the grantor has all the rights during their life to make the changes that they want. So earlier we talked about avoiding probate. So how does that happen, I guess, is the next big question. Well, it comes down to something called the affidavit for collection of personal property. If the total probate assets, and remember, probate assets are assets that are owned and completely and totally owned and do not have an official beneficiary designated. If the probate assets are under $75,000, then the interested party, usually the person going to receive the property, can collect the property with a simple affidavit. No probate is required so long as the probate assets are under $75,000. You also don't have to create a revocable living trust, and you can still avoid probate. It's an excellent strategy for certain people. For example, let's take a look at it this way. Let's say your assets are a house, an investment account, a bank account, and a retirement account, and you want to avoid probate. You could set up a revocable living trust, put all those assets in the revocable living trusts, and be done with it. You'll get to avoid probate. But what if you don't think your assets are going to change much and you want to save a little money from the outset? You can put your house into a transfer on death deed, put the bank account and the investment account under pay on death accounts, and the retirement account probably just has beneficiaries you can assign. All of a sudden, your four major assets are no longer probate assets. So the only probate assets you're going to own are like your furniture and your cookingware and your clothing, probably stuff that is going to be under $75,000. Now, this is a great strategy for retirees. And the reason I say that is retirees often are not going to be changing or at least increasing the amount of assets they have. Once we get it below $75,000, it's probably going to stay below $75,000. Younger people change their assets up a lot, accumulate more assets. It's not as reliable a way of avoiding probate, but it still is a possible way for people just starting out. A young family may not want to spend all the money on a revocable living trust and may only have their house as an asset. You put that on a transfer on death deed. If they die early, they could avoid probate. So that's my introduction to transfer on death deeds and pay on death accounts. I hope you liked today's video. If you did like today's video, please feel free to hit that like and subscribe button. It actually really helps support the channel. If you do like the video, we have a new video coming out every other Wednesday, and we literally have hundreds of hours of videos on estate planning on the YouTube channel, so feel free to check them out. If you have questions, leave them in the comments below, or send me an email, probably preferable that way. That said, until next time, this is Gregory Singleton with Signature Law.